All right, the court's staff's been made aware that the jury's arrived at a verdict, so we'll let them step down and announce it. Just out of respect to the jury, just keep your reactions, if any, to yourself, and we'll deal with it. All righty. All right, you can have a seat. All right, ladies and gentlemen of the jury, the court just, and I say this just to reference to you by numbers. We start down at the far right and run down this way, 1 through 6, upper right, 7 through 12. So, Miss Juror number 7, you are the foreperson? And the jury's arrived at a unanimous verdict?
Yes,
All right, if you would, please, ma'am, stand and announce that verdict on behalf of the jury.
We, the jury, find the defendant Blaise Allen Taylor for count 1, guilty of second-degree murder. For count 2, guilty of first-degree premeditated murder. For count 3, guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am. All right, ladies and gentlemen of the jury, you can back up just a second. Ladies and gentlemen of the jury, you've heard your foreperson, juror number 7, announce your verdict in this particular case, that you found Mr. Taylor guilty of, in count 1, second-degree murder, in count 2, first-degree premeditated murder, in counts 3 and 4, felony murder during the commission of a first-degree murder. I'll ask you if that is your individual verdict. If it is, you would indicate it is. If it's not, you would indicate it's not. Juror number 1, is that your individual verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Juror number 7, the foreperson, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your individual verdict?
Yes.
Juror number 10, is that your verdict?
Yes, sir.
Juror number 11, is that your verdict?
Yes.
Juror number 12, is that your verdict?
Yes.
Okay. All right, thank you very much. As you know, we'll need to discuss with the attorneys further issues in this case. Don't discuss the case any further. We'll get back with you here shortly. You can step down the hallway with the court officer. right, Mr. Taylor, you've heard the verdict of the jury in count one. They found you guilty of second-degree murder. That verdict, as well as the other counts, guilty in count two of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing. Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay. We'll take just probably a 15-minute break and let everyone settle down in terms of initial verdict. Come back and hear that proposed testimony under State versus Nesbitt, and then see Mr. Grant, Ms. Hollins, Mr. Joyner, what mitigating factors you want to submit and find that's necessary to submit to the jury. So,
The state's position is that Nesbitt only applies in death penalty cases.
what
As far
I'm
as
talking
doing-
about as far as victim impact 403 analysis.
Under Nesbitt, if it's life without parole, there is no analysis.
So you
That
can,
is, there's no dry run unless it is a death penalty case.
you can just have whatever that may be overly prejudicial.
No, it will be victim impact under pain.
Okay. And does Mr. Brand, Ms. Hollins, you have prepared proposed mitigating circumstances?
Yes, Your Honor, I think there are mitigating circumstances, mitigating factors we would argue to the jury.
Okay, all right, if you'll get those,
I think we need a minute probably.
okay, like I said, we'll take a short break, but let me ask the state this. There are cases with, obviously with the finding in count one, that wouldn't be considered by the jury, but there's also, I think it's Hargis versus State, that does apply to any felony murders, that your notice that you submitted, the felony murder portion, I think it's your number 2, wouldn't apply in counts 3 and 4.
Disagree, Your Honor, because it is Middlebrooks. It is not a Middlebrooks situation. It is within the legislation that amended the statute post-Middlebrooks, so that is something the state submits the jury can consider in a felony murder sentencing,
That an aggravating factor is the felony murder.
which is based upon that aggravating circumstance, which is above and beyond just the definition of felony murder.
What do you mean by that?
Well, that the jury would have to find the aggravating circumstance that, again, that it is not a Middlebrooks situation, so that state's position is the jury can consider that as an aggravating circumstance. That was the whole issue in Middlebrooks.
But there's some that would only apply to certain counts.
Yes, Your Honor, the age of the victim, certainly.
Right. All right, we'll take 15 minutes and then come back and hear from the defense in terms of mitigation.
Yes, Your Honor, the state would like to be heard or
Oh,
see
sure.
that. And
Yeah, let's then.
we have an argument about it.
Taylor, and by law, Mr. Taylor, your bond has to be revoked, so if you'll step into the back and talk with your attorney.
Welcome to 15 minutes.